zone. My name is Tommy Brooks, and I am the hearings officer in this matter. We are holding this hearing in part through electronic means. So before we turn to the particulars of the hearing, I want to turn things over to Ms. Smith to describe how that electronic process works.
Great. Thanks, Hearings Officer Brooks. Good evening, everyone. For the record, my name is Cynthia Smith. I'm an associate planner with the Community Development Department. I'm going to share my screen here, so give me a moment. Get myself oriented. Okay. So as the hearings officer had noted, the item before the hearings officer is an area variance for the front yard setback. I'll begin the hearing by explaining how members of the public who are joining us via Zoom and telephone can testify. After my Zoom instructions, I'll turn the hearings officer, the hearing back over to Hearings Officer Brooks for any further instructions. To follow, this will be followed by my oral staff report. The applicant will present their testimony and evidence. Then the public will be invited to testify, and then the applicant will be afforded a chance to make any rebuttal testimony, and then staff will have a chance to make any closing comments. Please understand that if there's a internet connection interruption, we will attempt to get back online as soon as possible. If this happens, please give us a couple minutes to activate the public hearing before you attempt to link or call back in. If your own connection gets interrupted, please attempt to join us back using the same link or phone number you used initially. In Zoom, there are two categories of participants. There are panelists and there are attendees. Panelists, you have the ability to mute your microphone and black out your video, which I will describe in a little bit, in a minute. You will be visible and you'll be heard and seen, so when we're recording this, just keep that in mind. As an attendee, your video will be active and the county's producer will control your microphone. This is an important distinction because anyone wishing to testify via Zoom will be promoted to panelist, so the audio and the video can be recorded. For those of us joining via Zoom, you will notice the button for your microphone is on the lower left, and right next to that is the button for the video. I point this out because you can mute yourself by clicking on the microphone, and you can also black yourself out for the video. If there's a time when you want to consult somebody else in your party or an attorney, you may want to mute your microphone so you're not recorded. Same thing with the video. If you want to black out the video, you can do that. Keep in mind, though, that if you don't mute your audio, but you black out your video, you will still be recorded. So I think the least you should do is mute your audio if you don't want to be recorded. So at this time, anybody who's, those folks who are joining us via Zoom, I believe there's at least two of you out there. Click on the raise hand button if you're wishing to testify. One at a time, I'm going to ask the promoter to elevate each person raising their hand, and I want to know if you are going to want to testify in support, neutral, or in opposition. So I'm going to stop sharing here. So we have two individuals participating via Zoom. If you could raise your hand if you're wanting to testify. I have Francie Peterson and Jean Matson. And don't know if there's, where are you? Nobody? Okay, so we're not seeing anybody who wants to testify via Zoom. We do not have anybody calling in on the telephone, so I'm not going to cover that. I'm going to go back to screen share. So just a minute. Okay, so thanks for working with me on that. And then just a couple other things with respect to the oral testimony. The hearings officer and staff are responsible for ensuring a respectful and orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member being removed from the hearing. In addition to oral testimony, you can also submit written testimony. If you are here in person, you can provide that written testimony to me prior to your testimony, your oral testimony. In addition, or for those people who are participating via Zoom, you can also submit written testimony. My email address is on the screen before you. Please keep in mind that if your electronic submittal is more than 20 pages, has color figures, or is larger than 8.5 by 11 printed size, we ask you to also submit a hard copy. I will go over these guidelines at the end of our hearing regarding the open record period. So I'd like to know if there is any objection to the hearing format. For those participating via Zoom, please raise your hand or press the raise hand button. And anybody else in this room, you object? Okay, hearing none. I will turn this back over to the hearings officer. So,
thanks, Ms. Smith. One question I do have, it sounds like the two people on Zoom aren't signed up to testify, but are there individuals in the room who are signed up to testify?
Oops, sorry. Yes, there are several individuals. We have the applicant. There's a party of 3 with the applicant, and then we have 5 individuals. Some or all of them will want to testify.
All right, thank you. So I will provide an opportunity for everyone to participate at the appropriate time, and we do continue to ask for your patience as we kind of work through all of this in this hybrid situation where some is occurring online and some is in person. The application is being considered through a quasi-judicial process. As a result, what I will do is consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and its land use regulations. The standards and applicable criteria relevant to this hearing and to the application were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and the staff report each are posted on the county's website, and they're also available directly from staff. As you come up, before you begin your comments, I ask that you state your name and address for the record. Even if your name is very simple, it's helpful to me if you spell it, just so we can keep things in order and accurate in any final decision. It is important that you direct all of your testimony to the standards and the applicable criteria. If you believe that a criterion applies that was not listed, you may address the unlisted criterion, but I urge you to also explain why the criterion must apply and to do so with specificity so that other participants can respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail that enables me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail that allows me to respond to that issue in my decision precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I'm obligated under that contract to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I do not know the applicant. I have only communicated with staff about the particulars of today's hearing, not the substance of the application, and I do not have any ex parte contacts to disclose. Based on the number of people that are signed up, I don't anticipate needing to set time limits for your live testimony. But I do reserve the right to do so, especially if it's getting really lengthy without addressing the criteria. So please, again, keep your comments addressed to the criteria that are applicable to this application. Before Before we begin, does anyone wish to challenge either my ability to hear this matter or to challenge the county's jurisdiction over this matter?
There are none.
All right. Then with no objections, I'm going to turn it back over to you, Ms. Smith, to deliver the staff report.
Thanks, Hearings Officer Brooks. I'm going to share my screen again. Thanks for your patience for going back and forth here on this. So again, I will provide my staff report. Again, this is Cynthia Smith with the County Planning Division. The file number is 247-21-000-183V. The subject property has an address of 15780 Tumbleweed Turn and Sisters. And for the hearings officer's reference, a lot of the comments talk about the main intersection coming into the subdivision, and this is where Sagewoods Lane comes in and meets Tumblewood Turn. So just for perspective, this intersection is what they're talking about, and the subject property is a rather higher profile property when you're coming into the subdivision. So a variance is an authorization for the construction or maintenance of a building or structure, or for the establishment or maintenance of a use of land which is prohibited by the zoning ordinance. In this case, the applicant is applying for an area variance, which does not concern a prohibited use. It's actually for a permitted use, but granting construction, alteration, or use of a structure that is not otherwise allowed in the zoning ordinance. So in their case, we are in a residential zone. The front yard setback is 20 feet, and that is from the property boundary that's adjacent to the road right-of-way, not the road surface, but the actual road right-of-way, which is much wider than the travel surface. Their approximate established front yard setback is 15 feet. Please note that the structure currently exists on the property through the issuance of a building permit, a fairly recent permit that has not been completely finalized. We're waiting on the outcome of this hearing procedure. And then just for perspective of the property, I'm going to just show the site plan. The blue line is the setback. And then the green building is the building. The green is the building, and this area that is shaded green is approximately 53 square feet that is encroaching in the front yard setback. They are requesting a 25% variance to the rule. The rule is 20, so they're asking for 5 feet, which is about 25%. I'm not going to go into detail. I'm just going to cover the main points that I asked the hearings officer to consider in his review, and I'll just highlight those 4 bullet points here. The first one is whether the applicant has adequately demonstrated that the literal application of the ordinance creates practical difficulties resulting in a greater private expense than public benefit. Also, requesting the hearings officer identify the condition creating the difficulty and whether that condition is unique to the applicant's site. Whether the applicant exercised due diligence in the situation and whether they should have known the front yard setback restriction. Part of this is if the hearings officer will need to determine if this is not a case of self-created difficulty, because the applicant relied in good faith and on their contractor and was unaware of either regulations and or the location of the property line. And then lastly, whether the proposed variance conforms with the comprehensive plan and the intent of the ordinance being varied. So that concludes my very brief oral staff report. I'd like to give the time over to the applicant and other parties, but I'm available for any questions if you have any.
All right. Thanks, Ms. Smith. I think I understand, especially based on the staff report, the questions you've teed up and how they track through. So I don't think I have specific questions for you right now, but I may on the follow-up. So we can go ahead and move to the applicant's presentation.
So will we just be oral, or will there be, oh, there we are.
Yeah.
Good evening, Hearings Officer Brooks. My name is Shannon McCabe. I'm an attorney with Lynch Conger. With me this evening are William and Robin Delaney. They are the applicants. Well, actually, I should correct that. They are the owners of the property. The original applicant was their contractor, David Stowe, through his attorney, Will Van Vactor. If you have any questions as we move along, I'm happy to answer any of the questions that are within my power, and Mr. and Mrs. Delaney are also open to answering any questions you may have. I do have some exhibits that we will be submitting. Unfortunately, I didn't get them to Ms. Smith electronically, so I'm not sure exactly how you want to handle that. We'll deal with it. So in addressing the criteria that have been set forth, the first item is the whether or not the literal application creates a practical hardship. And in support of the applicant's argument that the private expense outweighs the public benefit, we have with us a copy of a construction bid for the property. We also have the original construction bid from their contractor. And finally, we have information related to how those expenses have added up. So to begin with, the applicants have already invested $92,000 in the construction of this building. It's not a typical pole barn. It's significant improvements have been made to that. In addition, they have requested a bid from a private contractor that if the variance is not granted and removal and relocation 5 feet back from the current location is required, the cost will be $60,000 to demolish and remove the existing building, and then $190,000 to rebuild the building. As you might know, building materials have become exponentially more expensive than they were when this project began in December of 2020. So should I just go ahead and hold off on all of these till we're done, or do you want me to piecemeal? And those have been labeled as Exhibit 1 and Exhibit 5. Exhibit 1 is the contractor's bid for the demolition and reconstruction, and Exhibit 5 is the construction contract from William Delaney. Oh, sorry, the construction contract from David Stowe for Mr. Delaney. Based on what the applicants are requesting, the owners are requesting, it's a variation of 5 feet back. It's approximately 50 square feet into the setback area. If the variance is denied, the practical implication is that the building will be moved back 5 feet. It's an outright permitted use, and so it will be rebuilt. So there's very little public benefit to requiring the applicant to remove the building and relocate it 5 feet back. There have been no identified safety concerns. A variety of the concerns have been in relationship to the appearance of the property, and we've brought with us this evening as exhibits, which will come into additional play later, but we have copies of artist renderings of what the mature landscaping will look like, as well as photographs of the landscaping that has been installed so far, been planted so far. As you'll be able to see from the drawings and photographs that we've submitted, the Delaneys have gone to great lengths to try to improve this area and to make it match the rural nature of the setting. Again, this is a very small area that extends into the setback area. So we feel strongly that the private cost is significantly outweighed by any public benefit that may be derived from moving the building. The next criteria to be addressed is the condition creating the difficulty. In this case, what has occurred is the contractor who the owners hired, they relied on him to do all aspects of the building process. During his siting of the building, he erroneously chose the wrong property line in order to establish the setback. As you can see somewhat from the illustration submitted with the staff report, this particular property is on a road curvature. It's an irregular shaped lot. And the condition that's creating the difficulty is the fact that the building was established prior to the proper setback being identified. And again, the proper setback was delegated to the contractor to determine. What has created the difficulty is the fact that this lot is an irregular polygon shape, and the curvature, it's approximately 61 feet, and then it transitions through a small angle to a longer line. And it was the location of that curve was mismeasured by the contractor. Subsequent to the construction beginning and being performed, after substantial work had been done, the foundation had been poured, the framing had been done, it was discovered that the wrong property line had been used to establish the setback. The neighboring property owner had a survey done which identified the proper pin marks, which is what was used to ultimately determine that the 5-foot area is approximately what is at issue here. I have a copy of that survey map for your review as well.
I can get it.
So the condition that's created the difficulty here is that the contractor misidentified the proper property line in order to measure the setback area, and because of this unique curvature to this property, it was difficult for him to do that, and therefore this property encroaches into the setback area approximately 50 feet. So one other item that we'd like to mention is that in March of 2020, a very similar erroneous siting by a contractor occurred that was addressed in file number 247-20-000201-V. And in that file, again, it was a very similar circumstance where a contractor was asked to perform the duties and obligations of constructing the building, and it was ultimately discovered that their construction was approximately 9 feet, 11 feet into the setback area, 9 feet off of the property line. And that application was ultimately approved, including very similar languages as to the application that our clients have submitted. Would it be helpful for me to include a copy of this decision in the record, or?
That would be helpful for me, yes.
In addition to addressing the criteria related to the condition that's created the need for a variance, this decision also goes into detail regarding whether or not this would be considered a self-created difficulty. As I mentioned, in this case, the Delaney's hired a contractor who was experienced in rural construction of pole barns, RV garages. He was licensed. They had full faith in his ability to do his job. He assured them that he was doing his job, and it wasn't until much later in the construction project that they had any doubts regarding his ability to properly construct the building and determine the setbacks and comply with regulations. They relied in good faith on his representations that he could perform those duties, and so there was nothing that they did that in any way created this unfortunate human error that has occurred that has led us here today. And then the final piece of the variance that you're being asked to consider is whether or not this proposal conforms to the comprehensive plan. The plan and doesn't specifically reference variances. Even if it's inferred, as the staff has done in the staff report, that the purpose of the comprehensive plan as it applies to variances in the rural residential area is that it enhances the rural aesthetic and reduces conflicts between residences and right-of-ways. The criteria has been met, has been satisfied, because the pole barn or the RV barn garage is it's an outright permitted use. It's a common occurrence in rural areas, and the Delaney's have gone to great lengths to make sure that it blends in with the neighborhood, and through landscaping they have tried to shield it and make it look as nice as possible. There were no concerns regarding safety raised by either the Deschutes County Road Department, Transportation Planning, or any fire and safety departments. So the intersection of the right-of-way and the residence doesn't create any safety concerns. And there's also a LUBA case, Lord versus City of Oregon City, 43 OR LUBA 361 at page 387, which provides that if the comprehensive plan is silent on a matter, that criteria can be satisfied by referencing that. So, if this variance is denied, the applicants will have no choice but to tear down the structure and relocate it 5 feet back from its current location, and their recourse will be to file a lawsuit against their contractor seeking damages of close to $350,000. There's no other way to remedy this particular setback violation. They can't request a lot line adjustment or any other remedy from the code. And so ultimately, if this variance is denied, they and their contractor will go to significant expense to essentially remedy what was a mistake. It was human error, and by forcing them to tear down and relocate the building, it won't benefit anybody. So if you have any questions, I'm happy to answer them. Otherwise, we'll reserve our time.
All right. Yeah, I think I do have a few questions. Just a couple of things that I want to have clarified, but also just so I can understand the request a little bit. Because the encroachment is sort of it cuts off the corner of the building. Is your client's only recourse really to move the entire building, or have you explored other things that would reconfigure the building or redesign it to bring it within the setback? Tell me more about the need to just pick up the whole thing and move it back.
I have not discussed with Mr. and Mrs. Delaney whether or not they could essentially cut off a corner of the building. I'm assuming. I can answer that. Mr. Delaney is happy to answer that for you.
Yeah, we are currently talking to a couple of different contractors if there was any remedy for that to be adjusted, and there was no remedy. The way the foundation is poured and the structure is the way it's built, it would basically, you'd have to cut it off, and it would change the shape of the building and would not be accessible.
And safety.
Yeah, it just couldn't be done. The structure would cost more to rebuild that and put in place support to cut off relatively 53 square feet of it and then try to frame that back up and make it a whole. It wouldn't work. So I talked to 3 different contractors and they said there's nothing they could do.
Thank you. Ms. McCabe, I think another question I have for you, maybe it's just sort of the kind of the legal interpretation. This has to do with the first criterion that the literal application of the ordinance would create a practical difficulty. I think the way you and your client have presented this, you've described the difficulty and the greater private expense compared to the public benefit. I'm curious your take on the timing of it. Is it the literal application of the ordinance now that the building exists, or the literal application of the ordinance at the beginning before the building was constructed? I'm just looking for some position on what the temporal component of this is, and I think for your case it has to be that it's the literal application of the ordinance now, but I'm just wondering if you have any support for that in the code or any other argument.
It would be the literal application of the code now, but for the error made by the contractor, we wouldn't be applying for a variance. It was assumed that the contractor was properly siting the building. This is not a circumstance where we are coming and asking for a variance prior to construction. That was never the intent. The desire was to have the property and the building sited correctly on the property, so that none of this happened. There was no malicious intent or willful defiance of the rules, wherein the Delaney's thought they were going to sneak something by putting this in a setback. When the plans were submitted, they believed that the setbacks had been met based on the representations made by their contractor. This was, again, it was not a situation where they intentionally cited this within the setback, and had they done so, they would have requested the variance prior to any construction commencing. This was discovered well into the building process, and again, it was based in part on the curvature of the road and the contractor erroneously identifying the property line.
Thank you. One question just by way of clarification. I think I heard you say that, and I might have just misunderstood you, that the wrong property line was used to make the measurement, and that's in part what led to the error, or I kind of needed you to repeat that piece of it in terms of the process of measuring and the timing of that and when that occurred and what it was based on.
Sure. So I apologize, I didn't properly articulate that. What I was trying to express is that the shape of the property is, there's a fairly straight line, a slight angle that turns into a separate line of the property, and as you can see from the staff report, it might be easier to look at that diagram. It's on page...
I have that in front of me.
Yeah, it's on page 3. So what I'm referring to is there's a 61-foot section that then turns to a slight angle that's 145 feet. The contractor, when they were measuring the setback, extended the 61-foot line out and didn't account for the curve at the proper moment, and that's what created the discrepancy. Is because if the 61-foot portion had been 81 feet, we wouldn't be here today. He improperly measured that section and didn't properly account for where the curve occurred in the property line, and so that's what I was referring to by he chose the wrong property line to measure the setback. He chose the angular piece,
okay,
or he chose the straight piece as opposed to the angular.
Okay, thank you. That's a good clarification. And I guess just from this, I think this will be my final question, just in terms of how to interpret these code provisions. The distinguishing factor I hear you focusing on is that it was not the applicant or the property owners being the cause of this. It was their contractor. Is that how you think the county should interpret the code? Is that the applicant and the its contractor are distinguished, that it really needs to be the fault of the applicant personally?
I do, and the reason being is because when they hired a contractor to do this work for them, they designated him as their representative for the county. They put trust in him to do his job properly. From that point on, he was the point of contact. He was the expert in the field. I think that they exercised due diligence in hiring a licensed contractor to perform this work. If they couldn't rely on the contractor as far as being somebody that they could turn to answer questions, if they were responsible for overseeing every aspect of the construction, there would be less reason to hire a contractor. I mean, the reason that they did this was because this was not their area of expertise, and they wanted to have somebody else guide them through this process who they deemed to be knowledgeable and who they relied upon. And again, very similar findings in the March 2020 case, wherein same circumstances, and the application was approved. Particularly, it was noted that in that case, the applicant relied in good faith on their contractor, and they were unaware that the county was not checking required setbacks. And so I do think it's reasonable that the county make a distinction between the actual owner of the property and the representative that they select, because the owners didn't create the issue. They relied on somebody, and they paid him a great deal of money to do his job properly, and the fact that he didn't shouldn't further penalize them.
And can you, I guess, walk through the timing of this with me then? I guess who ultimately determined that the building as built is 15 feet from the property line? Was that someone on behalf of the applicant?
So as far as at what point it was determined that there was a violation to the setback, or at what point was the 15 feet specifically identified?
Yeah, I don't want to get into whether or not there was a violation, but just the factual determination that the building is 15 feet from the line. When was that determined?
So the exact measurement of 15 feet was determined, and I'll have to consult with my client. That was determined by Mr. Stowe?
Yes.
Based on the survey that was provided by one of the neighbors who had recently surveyed their property, wherein they were able to actually find additional pins to use to determine the distance that they needed to actually be. They needed to actually use to calculate the setback area. At this time, we have not requested that a surveyor come out and verify the measurement, particularly given that with surveyors' capacity as they are, we weren't going to have an opportunity to do that before the hearing. If we need to leave the record open in order to have a surveyor verify the measurement, I wouldn't think that an entire survey would be necessary, but perhaps just a surveyor to go out and provide a representative drawing. If that would be helpful to you and your decision, we're happy to do that.
So the survey you referred to that helped determine the 15 feet, is that the one that you submitted tonight, or you gave a copy of to Ms. Smith?
Yes.
And just to clarify, that was a survey that was done for a different purpose, but it gave you the information you needed to determine the location of the building.
Correct. It identified the location of property pins for adjoining properties that allowed the contractor to find the appropriate property line set.
Yeah, basically, sir, there was the one pin placement that was unaware of on the property when the contractor measured the four corners, relatively four corners. But there was the pin placement across the street at that 61-foot mark that determined the exact curvature of the lot. And that's where was not identified. And once he realized that there wasn't an identifying pin across the street, then he could determine exactly where that 61-foot curvature started. And then, excuse me, and then that's where they determined that the original, that it came over at 5 feet at the corner.
Thank you. That's helpful to understand the sort of the sequence of events.
Yeah, it was just a pin that was not identified.
Good. I think that's all the questions I have for the applicant. Unless you have anything else, you will have an opportunity to come back up on rebuttal.
Do you have anything else you want to add? Thank you.
All right, thanks. So this would bring us to the portion of the hearing where we would take live testimony for those who have signed up in support of the application. I don't know if we can identify those people.
Anybody in support? Oh, there's nobody in support?
Okay, thank you. Then we will move to the part of the hearing where we take other testimony for people who are not the applicant or in support. So whatever order they've signed up in.
Okay. Anybody want to start? Whoever wants to start. Right there. And just state your name and address before you speak.
My name is Janet Swartz, and my husband is Danny Swartz. We reside at 15761 Tumbleweed Turn, Sisters, Oregon, across the road from the Delaney's property. My husband and I purchased our home in the Sagewoods community 6 years ago and moved into our home permanently 5 years ago. We believe it is extremely important and vital to inform you of several facts that have not been provided to you prior to this hearing. We trust that you will take into consideration and include the following facts in rendering your decision regarding the Delaney area variance application. Fact: my husband was present with Mr. Delaney and his contractor when the contractor was digging a hole for the first pole installation on the southwest corner of the structure. Mr. Delaney and his contractor realized the hole was situated in the drain field due to the ground being wet. They discussed moving the stake 10 feet forward and proceeded to dig another hole to install this pole away from the drain field. Fact: it was strongly suggested to Mr. Delaney that a surveyor be contacted and retained prior to beginning any construction in order to avoid any incorrect measurements, violations, etc. However, he refused to do so, and as a result proceeded with installing the poles, pouring the foundation, etc., and thus violated the Deschutes County Code. Fact: we received a notice of application document by the Deschutes County Planning Division with a mailing date of Tuesday, March 2nd, 2021, for the subject property owner, Robin R. Delaney, applicant, requesting an area variance to the front yard setback requirement for an accessory building in the rural residential zone RR10. This application states that the accessory structure currently exists on the property through the issuance of building permit 247-20-006829-STR. However, the Delaney's chose to continue proceeding with this project, ignoring the fact that they violated and defied the county code. This structure has been completed. The perimeter fencing has been installed around this structure. The fencing is even closer to the road than the structure, and the new landscaping has been completed. Fact: there continues to be a blatant, willful, and defiant attitude displayed by the Delaneys in the sense of moving forward and completing their project despite knowingly violating the county code, and we are now expected to accept this variance application. Fact: we do realize and understand that every property owner has the legal right to remove trees and all other landscaping from their property. However, it is heartbreaking to have 10-plus fully matured evergreen pine trees, which once faced our front windows, destroyed and removed and replaced by what resembles a private airplane hangar. Fact: Mr. Delaney states in his applicant document that, quote, the HOA requires landscaping that will lessen the impact of the structure to allow the neighbors to view a more natural ranch setting, and that residents seem to think we will leave our property in its current state. The landscaping, perimeter fencing, and the structure will fit in aesthetically with the rest of the community, end quote. He also stated that, quote, our landscaping and fencing plan will help with the cosmetic issues that everyone seems to be upset about, end quote. Not only are his statements insulting, the structure, perimeter fencing, and landscaping are completed, and we can assure you that there is nothing, no amount of landscaping, enhancements, or camouflage that could even begin to lessen the detrimental impact of this so-called RV garage or ever create a more natural ranch setting. We do not appreciate or accept Mr. Delaney's attempt in appeasing or pacifying us, especially due to the fact that he knowingly violated the county code, yet proceeded with the construction. Fact: Mr. Delaney states in his applicant document that a lot of this noise being said here in the homeowner's complaints could have been dealt with if the HOA president was transparent with them during this process, end quote. We submit that all of this could have been avoided had Mr. Delaney not violated the county code and stopped construction immediately upon discovering the first stake was over the drain field. Fact: Mr. Delaney states in his applicant document, quote, that the cost of building materials and labor has increased exponentially. If Mr. Delaney had not proceeded with the construction and had not violated the county code, he would have no reason for concern about increasing costs. Fact: Mr. Delaney states in his applicant document that, quote, there are 7 other RV oversized garages in our community, some smaller, some larger. But since I live at the front of the community, it's not okay to have an RV garage. How is that fair? End quote. The fact is that none of the other garages are located at the front of any properties, nor are any of the other garages as enormous in size and height, nor have they been constructed in violation of any county code. Fact: Mr. Delaney states in his applicant document that, quote, the complaint should have zero impact on the decisions about this variance or for this variance application to go to a hearing. That will cause more financial hardship and stress on us, end quote. We believe that our facts and complaints are justifiable and should, in fact, have the greatest impact on the decision, what we hope will result in a denial of the area variance application. Fact: Mr. Delaney states in his applicant document that, quote, This project has taken an enormous toll on my wife and me, end quote. He specifies health issues, hospital stays, his wife's grieving the loss of her mother, etc. We do sympathize with them. We too have experienced serious health issues and loss. However, while unfortunate, these issues should have no bearing on the fact that he violated the county code and willfully and knowingly continued with the construction, perimeter fencing installation, and landscaping until completion. Fact, Mr. Delaney states in his applicant document that, quote, "We moved here intending to retire in a community where we could feel safe and happy. That has now gone entirely sideways because of fictional stories, untruths, etc., because people in this community don't like our RV garage or the fact that we removed trees on our property," end quote. We too moved here when we retired. However, if the so-called RV garage existed at the time we were looking at homes in our community, we would not have even considered purchasing our home. Our home is across the road from the Delaney's property, and the structure has greatly diminished our view and the overall ambiance of our community. The drawings and photos Mr. Delaney submitted previously are deceptive and do not accurately depict the size of the structure, the perimeter fencing, or the landscaping. We would appreciate and welcome you to visit this site to obtain an actual and accurate observation of the entire area. Fact, Mr. Delaney states in his applicant document that, quote, "I have communicated with Mr. Hunter on almost every decision and have taken his advice on different elements and changes to the building to help soften the impact on the community," end quote. What decisions did Mr. Delaney make that were not communicated to Mr. Hunter? Again, there is nothing that will help soften the impact this structure has created in our community. Fact, Mr. Delaney closed his document in stating, quote, "I would like to ask the county to please issue the variance so we can continue construction and finish this project. However, despite not receiving an area variance approval as of this date, the Delaneys did in fact continue construction of the structure, the perimeter fencing, and the landscaping. When we decided to add a master bedroom, a deck, and remodeled our home 2 years ago, we obtained every permit required by Deschutes County and retained a surveyor and an inspector. Is there now a double standard occurring? Do the county codes apply to only some rather than to all? Fact, all of us have choices, and we should be prepared to accept the consequences of our choices. The Delaneys chose to ignore and defy the county code, and thus continued with the construction of this massive structure. And only after the foundation was laid and the structure was built, then filed an area variance application, and now expect the county to grant them approval for their after-the-fact application, and their neighbors to endure and accept their choices and decisions with this county code violation. He portrays that he and his wife have become the, quote, victims, end quote, in this issue. However, they have caused our community to be the recipients of their choices, with the expectation that we accept this unsightly building and their feeble attempt in landscaping. None of this is acceptable. They violated and ignored the county code. Fact, our community consists primarily of single-story homes, with the majority of the properties having 1 acre each, some fewer. This structure is a massive 2-story industrial-style building with 2 side-by-side garage doors, has been utilized for several months, and continues to be. The notice of application clearly states that this completed structure currently exists on the property. This structure is in direct violation of the setback requirement and does not comply with the legal requirements and location. Fact, there is no justification for permitting the construction of this magnitude, after which the Delaney's applied for an area variance, knowing they violated the county code. This is a blatant illegal violation of the Deschutes County zoning ordinances and the Deschutes County Development Procedures Ordinance. We are extremely concerned this two-story building has affected our property values to suffer and decline. We also continue to question why the Delaney's were issued a permit to construct this massive building of this magnitude, height, and industrial style in the first place. Our community is not conducive to this building. Fact, throughout his applicant document, Mr. Delaney states that his contractor made a mistake. However, he omits the facts that he was present when his contractor, quote, made the mistake of digging into the drain field and therefore dug another hole 10 feet away for the first post in both my husband's and Mr. Delaney's presence. Should Mr. Delaney's area variance application be approved, what is the point of anyone else obtaining the required permits, adhering to the county codes, regulations, inspections, or obtaining surveys, as Mr. Delaney should have done? What message would you be sending to everyone else? Mr. Delaney could have completely prevented and avoided these violations and any and all of the resulting discourse. He should take responsibility for his actions and his choices rather than attempting to justify this entire scenario on the mistakes of others. We are hereby respectfully requesting that the Delaney post-construction submitted area variance to the front yard setback requirement application be denied. We trust that you will act accordingly, continue to uphold, honor, and adhere to the county code, serve as our voice, and advocate on our behalf. I respectfully submit, Janet Swartz.
Thank you, Ms. Schwartz. I do not have any questions for you.
Okay, thank you.
Anybody else want to?
My name is Stephen Hewlett. Last name is spelled Huillet. I preside at 15689 Paddock Green, and I have lived there for 24 years in this community. So I have seen all sorts of buildings and things going along, which has gone along. So my concerns are that Mr. Delaney should have, or had his contractor properly had his property surveyed by a certified surveyor prior to ever starting this project, and none of us will be here doing any of this today. The plans that were submitted to the county and the HOA for approval are not the plans that the building was built. The direction has been changed and the placement was changed. The contractor at that point should have said, I cannot continue until I see a new set of plans that is approved by the county with the proper setback, which none of this was done. And the HOA never received another set of plans prior to him already starting and moved the building to the current location. The next thing, the county inspector should have stopped the construction at the very first inspection until a new set of plans, since the set of plans that he had are not what the building was being built at in the same directions. And at this point, they should have stopped it, and until things were corrected, and they would have realized that the setback was wrong if there had been a surveyor's report done by a certified surveyor. Mr. Delaney has shown negligence on his part from the very beginning, because he was there at the very beginning when they started moving this. He knew what was happening. He told the contractor to go ahead. The contractor should not have gone ahead and moved this building prior to it being approved by the county of Deschutes. For this reason, I feel that the variance should be denied by Mr. Delaney, just because he has not shown due diligence in his part for what he was going to build. We built a house, we added onto our house. I had someone come, and the person that did the architectural, he got all the paperwork to make sure that the setback was not going to be infringed upon prior to me ever applying for the application. And that is what a normal due diligent person would do, especially when you're building something of this size, this close to the line. Thank you.
Thank you, Mr. Hewlett.
Do you have any questions?
I do not.
Anybody else want to speak? Oh. Anyone? Anyone? Better take myself off mute. I don't see anybody else in here wanting to testify, just double checking. Nope, okay. I did notice that we do have somebody on the phone, and Hearings Officer Brooks, I don't know if we want to see if that individual wants to testify.
It's someone who's just called in by phone, you mean?
Yeah, it looks, I just noticed it popped up.
Yeah, I think if you could ask that person if they had intended to show up to testify or not, would be good.
So the individual who's on the phone with the last four digits of 5862, if you could let us know if you want to testify. Don't, they're not unmuting, so does, I'm guessing not. I'm not hearing anything from them.
Okay.
The individual with that phone number 5862, if you could, oh, there we go, unmute. Do you want to testify?
No, I'm just listening in.
Okay, great, thank you. Okay, so we've, everybody's,
Testimony, then,
go ahead.
okay, then the applicant is free to come back up for a rebuttal period.
Thank you. Just a couple of things to address very briefly. Construction did in fact cease as of the December 22nd notice from the building safety director. The fencing and landscaping that has occurred is not part of the building permit process that is at issue for the construction of this RV garage. The other thing I would like to mention is that of the 58 homeowners, only a handful have objected. And Cynthia, if I could ask you a quick question. We received two correspondence from individuals who said that they sent them to you, but I'm not sure if they have. Is it better for, one is from John Hunter and the other is from Stephen Peterson? Did you receive both of those? Okay, great, then I won't provide you with copies. Thank you. The other issue I'd like to address is the fact that this building, again, it's an outright permitted use, and the size of the building is not at issue. The only issue related to this variance is the 5-foot area. It's, again, an outright permitted use, and it will be located on the property in substantially the same condition it's in now, with the exception of being moved back 5 feet. The contractor assured the Delaney's that the survey was not necessary, and they relied on his assurances as a building professional in not obtaining one prior to the construction. Again, they did not intentionally violate or seek out the encroachment into the setback area. It was a simple matter of human error, and requiring the removal and relocation of this building will present a significant financial hardship without public benefit. Thank you.
Mr. Cave, could you clarify? It sounded like you said that construction did cease on December 22nd upon notice from the county. Did I understand that correctly?
No, that was, on that date, the actual when the county inspector notified Mr. Stowe, they remeasured and did everything, and he thought at that point it was at 19 feet. And so the county took that in consideration and gave him permission to continue on to build. It wasn't until later on that they realized that it was over the 5 feet. And when it was within that 19 feet, was within that 20%, or that, excuse me, that 10% setback. So that's why the county gave him permission to continue on. So someone called in and said it was too close to the road. And that's where the inspector came out and they looked it over and they thought it was within that, only 1 foot within the setback. So they continued on with construction until
Like for a month.
about a month through. The reason why they continued on with the construction was that they had the framing up and the OSB out, and that was in December, and the weather was getting pretty bad, and so they wanted to protect the siding, so they put up the exterior siding and the roof on it. And then at that point, they realized that it was over that 10% setback line, and so they ceased construction from that point on. We never did any more construction. That was only at that point when they realized it was over the normal, what are the common setback, or the common variance?
The minor variance.
The minor variance, excuse me. That once they realized it wasn't within that minor variance, that's when they ceased construction, and that was in, I believe, somewhere in the second week of January. Second week of January, and there hasn't been any construction since. That was just to seize up the sides and the roof.
Okay, what construction remains to be done then on the building?
On the building, the exterior is paint. On the paint, on the interior, it's electrical, all the electrical, insulation, and interior siding.
Yeah, but the structure itself is complete.
Yes, sir.
Ms. McCabe, do you or your client have a response to the relationship between the location of the building as originally proposed and the drain field that's on the property?
So I believe Mr. Delaney can better describe the situation, but I'll give it a try. As you can see from the drawing submitted, page 3 of the application, the leach lines are present at the, I guess, would this be the north side of your property, or?
North side would be that side.
Okay,
and
trying
the
to
east. Yeah.
spatially orient myself so that I'm not giving you poor directions. But the leach line is located, would that be west?
South.
South, okay. Southwest of the current location, the location that's depicted on the site plan. And I'll let Mr. Delaney explain to you exactly what happened.
Yeah, so when the contractor brought out the other contractor to do the drilling for the foundation, not the foundation, but the poles, they incurred that it wasn't on the leach line, but it was at the very end of it where the overture comes out of the end of the leach line. So they were concerned that it would be too soft of a ground and that could possibly end up doing. So they moved the building forward so it wouldn't be caused by any kind of erosion or anything on the poles. So, but he's still assured that he was within that setback line when he moved that building forward.
I think that's all of the questions I have of the applicant, unless you have additional rebuttal.
Do you want to go ahead and mention that?
So I wanted to, first of all, thank you for being here today with us. And secondly, the landscaping that was recently put in, this was always the plan. And I know it's not the county to decide about our trees, but when we removed trees, we actually worked with a licensed arborist. And 7 of the 10 trees that we took down were a fire hazard and needed to come down. And the other ones were necessary in doing some other things so we could get the RV's garage in and out, or the RVs in and out of the garage. The landscaping that was recently put in was all approved by the HOA, and they've also submitted a letter in the last day or so approving the building, its structure, the impact on the community and all of those things, which you'll see in the records. But we have gone to great lengths, which was always part of the plan, is to build the garage and improve our property, not only from a fire safety perspective, but also for the need and honestly for the reason that we purchased this property. We always intended to build an RV garage. We were told by the previous owner an RV garage was already permitted or approved by the HOA. So I think we've come to learn in the last few days there's a lot of miscommunication that's gone on behalf of between the HOA, us being confused and things like that have led a lot of people in the community, including us and members that are here, to be upset and frustrated. So I hope that the facts that we presented today will help give you some clarity, and just knowing that the landscaping is its own separate submission to the HOA that they approved and have actually been coming over and saying it looks great. Thank you for making the improvements to the community. So thank you for letting me share that.
Thank you. I do not have any further questions then, so I think this will go back over to staff. If Ms. Smith is still here. Hi. I guess I don't know that I have specific questions just yet, but is there anything that staff needs to respond to based on what was presented during the live testimony?
I just wanted to clarify, and this is all noted in the written staff report, that when the building permit first came in, it had a site plan that depicted a setback and a orientation that was not built, and it continued to be built until the building official was notified that something's not right. And so in December, the building safety director did issue a stop work order because of that. There was a mention by Mr. Delaney about this 19 feet and a minor variance. Well, that may have been a call by the building official. However, the planning division would not permit a 19-foot setback without a formal approval of a minor variance, which gives you 10% of the rule versus the 25 that they're requesting now. So, and it wasn't until January 6th that the contractor submitted a revised site plan illustrating 21 feet and a different orientation. So I just wanted to clarify that planning did not approve a 19-foot setback with the understanding that it might be 19 feet. That could have been the building official that authorized the continuing of building of the structure. Planning would not have signed off on that. Planning re-signed off on the revised revised site plan that was submitted that showed 21 feet as the setback. So just wanted to clarify that. And then there were some comments that were submitted in the last couple weeks that have been included in the record. I just wanted to point that out. I didn't mention that earlier. And some of the comments that were submitted in writing and also tonight talk about the fencing that may be located in the front yard. And County code does regulate fencing in the front yard setback. And although this fencing may not be an issue, I just want to point it out that if anything is located within the front yard setback and is site obscuring, it needs to be 3.5 feet tall or less, unless you can see through it. If you can see through it, then it can be taller than 3.5 feet and be located within the 20-foot front yard setback. If it is site obscuring and is taller than 3.5 feet, it needs to be set back 20 feet or more. By seeing the pictures of the fencing, there may not be a violation as long as the fencing is located on their property. If it's located in the road right-of-way easement, then there is an issue. But there is, just wanted to point that out, there is a section of code that we do regulate fencing, and I can definitely put that into the record if necessary. And that's all I have to say at this time.
Could you, though, you referenced that there was a staff work order issued. Could you state again what the date of that was?
In the staff report, I note December 22nd, the building official did a stop work order. The building official was notified by planning staff that there was a concern about where the building was located, and they continued to build. And so planning staff notified the building official and code enforcement management of this issue, although there was not a formal code enforcement complaint submitted at the time. And so the building official decided to do a stop work order for them to figure out or remeasure the front yard setback.
Okay. And not to put you on the spot too much, but the applicant had referenced a prior decision from March of 2020 in a different variance application. Is that anything you can speak to now? I mean, you certainly don't have to. I just didn't know if you were familiar with that decision.
No, it may be referenced in the staff report. We did use a bit of that decision. I'm just trying to look through the staff report right now.
Okay, maybe I didn't catch that was the same one.
It was helpful that the applicant submitted it into the record, because I don't know if I did. I submitted 3 other decisions that we referenced.
Mm-hmm.
That was submitted, it was just uploaded yesterday or today onto the system.
Okay. Okay, that's helpful. I just didn't know. It looks like they'll have the ones in the staff report have different file numbers, but I'll be able to sort through all that.
Yeah, I can make, that particular structure had been in existence for much longer than the subject structure. It was years, 6 or more years, if I remember. So it had been established on the property for much longer.
Right. Okay, I don't have any other questions for the staff, so it doesn't sound like there's any procedural issues to work through. I just want to, since I can't really see the room, make sure there's no one jumping up to say anything. So with that, is that accurate?
Air conditioning.
It was probably the air conditioning.
Oh, okay. All right. So then with that, then we will close the hearing on this and close the record. And I will take this under advisement.
Actually, could we hold off for just one moment?
So
There might be a request to leave the written record open.
sorry. Okay, that's what I was trying to solicit. If there was
Okay.
anything else procedurally.
Yeah, sorry.
So,
Okay.
Yeah, sorry, we didn't
keep
quite
the
catch
record-
that cue.
keep the record open until I hear a request.
If we can.
Okay, just one moment, they're going to discuss it.
If we could leave the record open so that we are able to submit a written closing, that would be great.
Just so I can clarify, Ms. McCabe, you are asking not for the introduction of any new evidence, just an additional argument?
Yes, just to submit, to kind of synthesize what we've done here today, and no introduction of new evidence or facts.
Bear with me for just 1 minute. I kind of want to refresh how that works through the county's code. Let me just sort of tell you what I'm struggling with, which is, so this is section 2224-140 of the county's code, and it speaks to any party being entitled to a continuance of the initial evidentiary hearing, which this is. And then it says under the following circumstances. One is where additional documents are being submitted by any party, which I don't think is applicable here. Upon a party's request to present additional evidence and testimony, and then it defines additional documents or evidence as documents or evidence containing new facts or analysis that are submitted after the notice of the hearing. I'm hesitant to leave the record open just to make an additional argument, but I think you are entitled, if you want to have additional evidence submitted, and of course other parties would then be able to rebut that, and then you would get your a final argument, and that's sort of through the statutory procedure. So I guess I will entertain a request to leave it open for additional evidence and testimony, but not for additional argument.
Okay.
Anybody want to submit any additional evidence?
And that does go the same for any party is entitled to request to leave the record open for additional evidence. It's not just the applicant. I do want to make that clear. So I'm just responding to the applicant's request at the moment. Ms. Smith?
We do have the two people online are requesting that it be left open for more rebuttal in writing, or just leave the record open. So I would think the standard
Okay.
7 and then 7-7 would.
Okay. Ms. McCabe, does that make sense to you that the record then would be left open for all parties for 7 days for new evidence and testimony? Other parties would then be able to rebut and what comes in those 7 days, and then the applicant would get 7 days for a final legal argument?
Yes, we're fine with that.
Okay. And just to sort of clarify how the county's code works, even though I think that request technically came from another party, the legal effect of this too is that it would extend the 150-day deadline by the same amount of time. And I just want to make sure you're aware of that and okay with that part of the process.
And we approve that.
Okay. So let me do my date calculations here just to be clear. And I will say this more formally in a second, and I think Ms. Smith might have some instructions for submitting this additional information, but it looks like those dates will be the 27th for the open record period, August 3rd for the rebuttal period, and August 10th for the applicant's final legal argument. I calculated that correctly. Okay, so before I sort of state those dates again, Ms. Smith, can you go over the procedure for how people will submit or can submit information during these periods to you?
Yes, I'm gonna share my screen again, just so we can get it into everybody's heads. So the first 7 days will end on July 27th, and that is for any new information coming into the record. It needs to be submitted by 5 p.m. On the 27th. You can email stuff to me, you can hand deliver it, you can mail it in. If you do email, just keep in mind that if it's more than 20 pages, it has color figures, or it needs to be printed on larger than 8.5 by 11 size paper, then we ask you to also submit a hard copy. All the documents need to come to me, the case planner, Cynthia Smith. My email address is on the screen right now. Do not direct anything to the hearings officer. I will, rest assured, I'll get it to him. And then, same thing, August 3rd will be the next 7 days, and that's for rebuttal period. That is to rebut anything that is currently in the record. And then August 10th, the last 7 days is for the applicant only. That is for their final arguments. Like I said, please make sure you get it in by 5 p.m. Don't try to send something at 4:58 and think it's going to get to me, because it may not get to me till 5:01, and then we will not recognize that. There's something else I need to say that, knowing that everybody's paying attention to the record, we upload things to our e-permitting site. It will be once I try to upload those things by the soon after the deadline of each of those 7 days. I can send you links for, I don't have them right now on the screen, but if you, I can send information on e-permitting, on how to obtain those records. You can also go to Oregon Deschutes Dial, and it takes a few days to get see those documents on Dial, so your quickest way of seeing things will be through our e-permitting site. Oh, yes, thank you. The first bullet point, do not send us links or cloud storage, Dropbox, or anything like that. We're not going to take responsibility for retrieving that information. So if you want something submitted into the record, you create the document for us and submit it that way. Do not send a link or a cloud storage service. Thank you. So that's all I have to say.
Okay. And I'll just reiterate, it is required that you do submit it to Ms. Smith at that email address. If it goes just to me, you run the risk that it doesn't get seen, doesn't get captured, and I will likely exclude it from the record. So please follow those instructions. So with that, at the request of the participants, we are going to close the hearing, but we're going to extend the record in this matter. The record is going to be open for what I'll refer to as an open record period until July 27th, 2021 at 5 p.m. That is for any participant to provide evidence or argument to the record. Following that, the record will be open until August 3rd solely for rebuttal. It can be rebuttal evidence or rebuttal argument, but it needs to rebut evidence that's already in the record. That will be the rebuttal period, and again, that concludes on August 3rd at 5 p.m. And then following that time period, the record is going to be open solely for the applicant to submit a final legal argument that has no new facts in this only argument. And that's August 10th at 5 p.m. Any questions about that? All right. Well, with that, then I think we have concluded, and I appreciate everyone's time and attention and for continuing to navigate these hybrid hearings. I think we're also getting used to it, but it's sort of the way things are now and probably will be for a while. So thank you.
Thank you.